Ladies and gentlemen, welcome to another shocking expose of the family court, and this one is really going to get you going. Today, I am exploring the question, can blubbering at the right time, in the right places, in the family court really help to throw your ex under the family court bus? But before I cry my way through it, let me run my excellent introduction. I am Philip Kedge, a retired Police Chief Inspector, the Director of the Mckenzie Friend UK Network, founder of the national campaign of #LikeNotHate, and fearless family court vlogger. I have been a Mckenzie Friend for over a decade, and in all my vlogs, my views and opinions are, of course, entirely my own. Let me start by explaining what I believe. 20% of family court child arrangement cases don't have any allegations of abuse. We know that because that is what the president of the family court tells us. And here he is, Sir Andrew McFarlane, aka Mr. Dressy Uppy, the invisible leader of the broken, inept, incompetent and incomprehensible family court system. Secondly, I believe that in another 20% of cases, there are serious and significant issues around domestic abuse that needs the full force of Practice Directions 12J to be applied, where children and parents need to be protected from such abhorrent abuse. Now, let me be crystal clear. In this vlog, I am not talking about or referring to those kind of cases. So, that leaves the remaining 60% of family court service users, and from what I observe, these are made up of parents, usually the resident parent, who are statistically mostly mothers, motivated by revenge, hurt feelings, unfettered emotions and irrational anxieties, making spurious allegations based on hate, whilst weaponising the children against the non-resident parent, who are mostly fathers, to minimise, reduce, restrict or deny child contact. And of course, and I have no doubt that you will embrace this sentiment, that they are encouraged and supported by the all too often sick in the head family lawyers who can easily manipulate the family court, who stir the pot of acrimony and hate for their own financial gain, engage in thousands of pounds of totally unnecessary work and leave people in crippling financial debt, and have absolutely no professional duty of care to any child. How disgraceful is that? Now, these spiteful, vengeful and emotionally challenged resident parents who don't care about destroying their children's childhoods have potentially one huge weapon up their sleeves, which I'm going to formally name as being the blubber factor. And yes folks, blubbering in the family court at the right time, in the right places, particularly in front of judges from Planet Stupid, can be a significant advantage in helping to throw your ex under the family court bus. And there is even case law that supports it. Let's take a look. In layperson terms, case law dictates that a judge may look to demeanor, body language, non-verbal and verbal cues, and general presentation when assessing the integrity, honesty and evidence of a witness. Now, a judge may not place undue emphasis on these factors, and it is not a substitute for the detailed analysis of evidence, but they are factors that could influence decisions and the balance of probability. So, that's potentially a significant problem for the non-resident parent, who are mostly fathers. We know through crime surveys that in a third of domestic abuse cases, the victim is a man. However, that statistic is rarely reflected in the family court, From what I see, fathers are perhaps far less inclined to raise issues of domestic abuse, to only want to move forward to re-establish contact with their children, to draw a line on the past and to try and build positive co-parenting relationships. Conversely, again from what I observe, it is often the resident parent, who are mostly mothers, raising spurious allegations based on hate and creating a battlefield of conflict to manipulate the family court to minimise, reduce, restrict or deny contact. When it comes to the blubber factor, men may be far more reluctant to demonstrate emotions, being more stoic, hiding feelings, wearing a suit of armour that can often come across as being more detached and more emotionally distanced. How many times have I supported fathers with expressions such as, "Keep your chin up, let's get through this together, be strong," whilst on the other side, mothers may be far more willing, when it suits them, to show emotions with expressions of false self-pitying victimhood as part of the mad woke era that appears to have fully infiltrated the family court. It's not really that difficult to turn on the tap of tears. But that potential issue of unfairness, of an uneven playing field, is even more compounded under the special measures an alleged victim of domestic abuse can demand when sitting in court, which of course is the screen to hide behind to break all visible contact with their ex. So, as the judge has full sight of the mother's demeanour throughout the hearing and can make judgments based on the tears, facial expressions and general histrionics, the father is blinded and has no access to that information and potential evidence, as they cannot see it and therefore cannot challenge it. That can't by any reasonable standard be fair. I have witnessed on many occasions in court the mother's barrister trying to highlight the demeanour of the father, whilst at the same time the litigant person has not once been permitted to set eyes on the mother. Again, that is not acceptable. Now, this next bit is going to be very interesting indeed. Of course, when COVID struck and we hailed the dawn of the remote attendance hearings, the issues around witness demeanour seemed to dramatically change. By looking at a video screen with all parties present in photo booths type boxes, it became almost impossible for judges to get any sense of demeanour, body language and non-verbal cues, along with general presentation. Indeed, there was a noticeable change in the general atmosphere where the remote hearing court process positively became much more focused, much more pragmatic and much more evidence-based, and the opportunity for histrionics seemed to pretty much disappear. Judges in the main are not permitting mothers to sit back behind blank computer screens, and of course blubbering online doesn't really work. Interestingly, I saw mothers starting to actually man up and present themselves more stoically like the fathers. I know that's going to offend the feminist woke sisterhood, but honestly, I don't care. Be upset. I'm a champion of manhood and have no intention of becoming a castrated, frontal lobe, lobotomised, family court man clone. So, have remote hearings and being unable to determine demeanour changed the thinking of the courts? Well, it has certainly raised the debate. Let's take a look. The Court of Appeal in the case of Re P, a child remote hearing 2020 EWFC 32, The judge, who was Mr. Dressy-Uppy himself, stated, and I paraphrase, that remote hearings are a very poor substitute to seeing that person fully present before the court. In a second Court of Appeal hearing a couple of weeks later, in RA Children Remote Hearing, Care and Placement Orders 2020 EWCA 583, again presided by Mr. Dressy-Uppy, who emphasised that, and I paraphrase again, a judge will be in a better position to assess the evidence of a witness who gives evidence live from a witness box than one who speaks over a video link. However, there has emerged one more recent Court of Appeal case. The Local Authority versus a Mother 2020 EWHC 1086 before Mrs. Justice Levin. In this case, Judge Levin appears to, and perhaps bravely, contradict and challenge the thinking of Mr. Dressy-Uppy. Let's take a look at what she says. One important factor in a decision whether to proceed, particularly in a fact-finding case, is the question of whether the judge will be in a less good position to judge whether or not the witnesses are telling the truth if the case is conducted remotely. Lady Levin then refers to a 2018 case, EWCA 1391, at paragraphs 36 and 40. That states, generally speaking, it is no longer considered that inability to assess the demeanor of witnesses puts appellate judges in a permanent position of disadvantage as against the trial judge. That is because it has increasingly been recognised that it is usually unreliable and often dangerous to draw a conclusion from a witness's demeanour as to the likelihood that the witness is telling the truth. Then at paragraph 40, this is not to say that judges or jurors lack the ability to tell whether witnesses are lying. Still, less does it follow that there is no value in oral evidence. But research confirms that people do not in fact generally rely on demeanour to detect deception, but on the fact that liars are more likely to tell stories that are illogical, implausible, internally inconsistent, and contain fewer details than persons telling the truth. Bingo! That hits the nail on the head. Having considered these comments, Lady Justice Levin concludes with her own case, stating, having considered the matter closely, my own view is that it is not possible to say as a generality whether it is easier to tell whether a witness is telling the truth in court rather than remotely. It is clear from Re A that the Court of Appeal is not saying that all fact-finding cases should be adjourned because fact-finding is an exercise which it is not appropriate to undertake remotely. Demeanour will often not be a good guide to truthfulness. Some people are much better at lying than others, and that will be no different whether they do so remotely or in court. Certainly, in court, the demeanour of a witness or anyone else in court will often be more obvious to the judge, but that does not mean it will be more illuminating. This is clearly an enlightened judge from Planet Common Sense versus others who come from Planet Stupid. So there is no reason why final hearings or fact-finding hearings cannot be held remotely. And as such, that raises the obvious valid argument that a person's demeanour is not and should not be a factor in the family courts, as it is totally subjective, unreliable, and open to the perception of gender and cultural bias. Removing demeanour as a factor in the family courts would provide consistency across all hearings, whether in person or remote, and a level playing field. It would mean that judges can return to focusing solely on evidence, Thirdly, it would go a long way in reducing the often unsightly and quite frankly hysterical performances that attempt to manipulate the family court. As things stand, from my personal perspective, I see the family court rapidly turning into a deranged and destructive witch hunt against all things masculine and masculinity. And this family court madness now needs to stop. That's me done, and it leaves me only to now invite you to watch perhaps the most important family court vlog you will ever see. Why the family court is so terrifying, the blueprint of hate. Until next time, stay strong.